Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. One of the questions that I often receive in a transitioning market has to do with what a real estate broker can do to attract clients. Whether it's the buyer or the seller, how can I incentivize a party to work with me? And the most popular suggestion I hear is, can I offer some sort of payment back to either the buyer or the seller in the form of, for example, with a buyer, maybe it's payment of closing costs for, or maybe it's for a buyer, it's offering to pay for an appraisal fee or an inspection report. Or if it's the seller, maybe it's an offer to pay for staging in the home or some other service that would benefit the seller in marketing the property. And the answer to all of those questions is yes, broker. With the permission of your designated broker, you can give any or all of your compensation back to either of the parties in the transaction. Sometimes brokers say, whoa, that doesn't make sense. We've always heard that you can't use kickbacks or make rebates. Whatever those terms might mean in any other context, set that understanding aside for a minute. Because here's what the Department of Licensing has to say about the concept we're actually discussing right now. Can you give money back to a buyer or a seller in a transaction via the payment of some or offsetting of some costs that that buyer or seller would otherwise incur in that transaction through your commission? And the answer is yes. DOL analyzes that as doing nothing more than reducing the amount of compensation you're charging. DOL doesn't care if you charge nothing to a consumer for your services, but I guarantee you your designated broker will care. So if you are inclined to incentivize a buyer or seller to work with you, make sure that your designated broker is okay with the program that you're offering to your buyer or seller. With your designated broker's blessings, then you can incentivize buyers or sellers to work with you by offering to pay some service back for them, to pay for some service for them. That relates or transitions nicely to another question I often get. Setting is something like this. My child is involved in a sports team. All of the other parents have to pay some sum of money every year to support the sports team. Could I agree or could I offer to make a contribution to that sports team if the parents buy or sell with me? Or maybe it's a school, or maybe it's some other charitable organization. Can I agree in the name of my client to make a contribution to that charity or some other organization? And the answer to that question, just like the prior question, is yes. DOL sees that as you giving money back to your client. And if you want to give it back to them in the form of making a donation in their name at closing, that's fine. As an aside, you could also wait until the transaction closes and do anything you want with the money, because then it's your own money. It's already been paid to you. So again, with the caveat of a minute ago, get your DB's approval, and then you can agree to make a contribution in your client's name. Related topic, can I, as a real estate broker, offer to pay a referral fee to an unlicensed entity? And the answer is confused, because state law says one thing, federal law says another. State law says yes, you can offer to pay a referral fee to an unlicensed person if the referral is not contingent on a successful outcome. So you can't offer to give a $100 Amazon card, for example, to anybody who refers a client to you if the buyer, for example, closes a transaction, or if the seller lists the property with you. But you can say, if you refer a buyer or seller to me, I will give you a $100 Amazon card. If you do that, then you owe that $100 card when the referral is made to you. Delivery cannot be contingent on a successful outcome. Federal law, however, the Real Estate Settlement Procedures Act, RESPA, says that it is unlawful to give anything of value to any third party, to any settlement service provider. It's unlawful to give anything of value to any settlement service provider in exchange for the referral of business. And the definition of settlement service provider is so broad that at least it's arguable that that definition could include an unlicensed third party. If you are going to offer a referral fee that would conform to state law, but at least has the potential for violating federal law, again, make sure you have your designated broker's blessings, maybe even talk to your own lawyer before you do that. Slightly more complicated question. Can I, as the listing broker, incentivize the sale of my seller's property by offering a buyer broker's bonus? In other words, can either I or my seller offer to a buyer's broker, if you bring a ready, willing, and able buyer for this property, in addition to the stated SOC, we will give you $5,000. We'll give you a one-week cruise. We'll give you a new car. I've actually heard all of those as suggested ideas for incentives to a buyer's broker to bring a ready, willing, and able buyer. And the answer to that question is, from the seller's and listing broker's perspective, absolutely. You can make all those offers that you want. Makes the buyer broker's job a little bit harder. Why? Because the buyer broker is now in a potential conflict situation with their buyer, meaning that buyer broker has to disclose that offer of a bonus or a gift to the buyer. The argument would go something like this. Two very similarly situated properties, one offers an SOC and one offers the same SOC plus a $5,000 buyer broker bonus. If buyer buys that property without knowing that buyer broker is getting that buyer broker bonus and then later regrets that decision, is there an argument that buyer broker pushed buyer broker towards that property so that buyer broker would receive the bonus? That problem is solved by buyer broker disclosing in writing, so you can prove it later, to the buyer that if buyer purchases this property, buyer broker will receive this additional compensation. Now, what's likely to happen when you make that disclosure to the buyer? What's likely to happen is that $5,000 now becomes negotiable with the seller for the purchase price or extras or closing costs or whatever it might be, right? And if it's a cruise or a new car, then the value of that purchase might become something that buyer considers as further negotiability with the seller. And if that's the case, then so be it. That's the case. What's very clear in the situation is that you as buyer's broker have a duty to disclose that additional gift or compensation over and above a more traditional SOC to the buyer. Now, here's where I don't want you to send me 1,000 emails, because I know they're coming. I know that there is no traditional SOC, there's no predetermined, there's no stated amount of compensation that every seller is going to pay to every buyer's broker. There's no industry standard. We've got a huge antitrust issue if anybody tried to say that there was. That, in agreement with that, it's also true to say that you as a buyer's broker know if there is an additional buyer's bonus being offered, an additional incentive over the SOC advertised in the listing. That's the scenario I'm talking about. Lots covered here. In a transitioning market, we're seeing lots and lots of brokers trying to generate business, and these are the questions that often drive that discussion. If you have questions on these topics or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.